Please be seated. We're on the record in case CV150125, Mukesh Narang et al. Versus Sudhir Rajan et al. This is the time set for oral argument. Counsel, you both have 20 minutes to present your argument. Mr. Arpad?
Yes, Your Honor.
Okay. If you would, just let us know what time you want to set aside for any rebuttal. You do have the counter on the podium there to keep track of your time. Keep in mind, we've read the briefs, we're familiar with the record, so we know your case very well. All right, Mr.
We did.
Judge Gemmel knows the case very, very well. He's the expert, and all questions, issues should be directed towards him. So with that being said, Mr. Arpad, your argument?
Thank you, Your Honor. May it please the Court. I'd like to reserve 3 or 4 minutes at the end, but I think it's obviously more important to address any questions the Court has, so that will be the first priority. And if I may, I'll just go straight to the scenarios that the Court had sent us a few days ago to outline the key issue in the case. The first scenario that the Court had suggested is that the statute at issue 1220A and the common law prohibit partition where there is an estate for years or a life estate and a remainder beneficiary, and therefore partition is not available. That is close to, but not precisely, our position. Our position is a little bit narrower in that I think the language of the statute suggests fairly that you can partition between the two concurrent possessory tenants. So, for instance, if Dr. Malhotra had brought this partition action to only partition the remainder of his estate as against Neera and her comparable possessory interest, you could do that. It wouldn't be very practical because you might have trouble selling a 4 or 5 year term interest that reverts back to somebody else at the end of that. But in theory, you can do it. And I think even the Luker case says Mr. Luker was entitled to partition his life estate if he wanted to. Forcing out a trustor during the term of the Cupert arguably violates the Cupert. That's a somewhat complicated and debatable issue, but it does not violate 1220A. Purely future estates, by contrast, can't be partitioned at all because there is no possessory interest to partition. And I think that's what the Beach case says. And I cited the Beach case many times because I think it provides a really nice summary, provides you plenty of other cases and sources that you can take a look at for background, and so we didn't give you a bunch of string cites and so forth for those principles. More broadly, the holders of current term interest cannot use partition to take a portion of the property in fee to participate, in the words of the Luker case, or to force a sale of the fee in order to satisfy whatever interests they may have. Another way to think of it is, under the common law, when somebody creates a life estate, whether it's my property and I give away a life estate and reserve the remainder, or the other way around, or if I give the whole thing to 2 different people, I give the life estate to one person and the remainder to somebody else, I am not giving the life tenant a sufficient level of control that they can then turn around and sell out or force out the remainder interest. That's how the common law traditionally viewed it. So by nature, the life estate or the term estate simply doesn't have that power, doesn't have that ability to say, you know, I changed my mind, I'd really like to get this back and do it on my terms. A donor can write a document in a way that allows them to keep the power. And in fact, the Cuperts that you have in this case are written. They say the donor, the trustor, can, if he decides he'd rather live somewhere else, sell his interest, and the remainder beneficiaries can't do anything about that. They get an equivalent interest in something else. So he retained a limited power to sell. What that does not do, though, is give...
that would be true if there was only one Cupert.
That was the very thing I was going to say.
We've been saying QPRT, but Cupert, huh?
Estate planners traditionally say Cupert, just like they say Grat and Grit and Crut. And
no, I'm into the Grat part.
Okay, fair enough.
I don't know about those others.
QPRT is just fine, but I'll probably continue to call it a Cupert because I've been doing that for a little while now.
Right. So if there was one Cupert, then what you said, if I now recall correctly, would be accurate. But Here we have two Cuperts and two people that don't agree anymore.
That's precisely true, Your Honor. And so nothing about the nature of the Cupert or the nature of the interest created under it gives one Cupert beneficiary, occupancy interest beneficiary, the ability to kick out the remainder beneficiaries or the future interest beneficiaries under the other Cupert. They have the power to do it under their own Cupert. So in theory, Dr. Malhotra's Cupert could sell his half of the house to somebody. But again, there's not much of a market for a half interest in a house that's half owned by somebody else who you don't have the ability to get rid of. Dr. Malhotra also would not be able to use the partition statutes against his own future interest holders under his Cupert, but that's probably an academic question because he can do that piece of it voluntarily. He doesn't need the partition statutes. The second scenario was that 121220A is not applicable because the trustors of the Cuperts own the property equally and the interests are concurrent. And I believe that's close to, but not quite, Dr. Malhotra's position. The trustors pretty clearly don't own the property. They're the ones who created it, deeded in the property. They gave away something. They have a current occupancy interest with a lot of control over the property during their term, but they don't own the property.
What if the word trustors in number 2 should have been trustees?
I think that is their position. Or trusts, as they've said many times. Either the trust sort of conceptualizing it as an entity own it, or the trustees own it in fee. And I think we've briefed pretty extensively why we think that's not the case. I'm happy to go over it further if you have questions. But the limitations on their authority and the fact that the whole purpose of a Cupert is to pass on the trust property means that this is not a typical trust that you would think of where somebody puts in marketable securities and then you have prudent investor rules that say you have to have so much income and you have to have so much appreciation and here's how you divvy it up. And the house isn't a very good asset for doing that, so therefore you would infer from that that the trustee has the ability to sell the house because it's just the wrong kind of asset to have in the trust. Here, the house is the asset that was put into the trust, and the whole purpose of it was to pass it on down in the family, unless the occupancy beneficiaries change their mind, and because there are two Cuperts, change their mind jointly.
I think you're about to get to number 3.
I am about to get to number 3. This is saying that ARS 121220A creates an exception when the interests are non-concurrent, and that you can, in fact, partition or sell the property as long as you make sure to that you don't prejudice the remainder interest holders. And I think that's actually correct in a narrow way. In other words, the common law probably would have been that because none of the interests are concurrent, really, truly concurrent, none of these folks had partition powers against each other. And because 1220A says, it actually says that you can have a duration mismatch. It says that if you bring a partition action against someone who has an equal or greater estate, so in our example, Dr. Malhotra has a lesser term interest, Nero Malhotra has a greater term interest. I think this does expand traditional partition law by saying, okay, you can have a partition action, but you can only partition the part that's concurrent. And the reason I think you have to interpret, well, the two reasons I think you have to interpret it that way is one, because we've got the Texas history and case law suggesting that 100 years ago, this language, that's what they interpreted as meaning. When the legislature adopted this statute, I wasn't able to confirm it absolutely, but it appears to me it was adopted from Texas, which had been around a little bit longer than we had. That's what they understood it to mean, and so understood it to mean. And so if you want to take on a different meaning, you really have to make some counterfactual assumptions about the legislature today writing on a blank slate and using prejudice to mean what we would think it would mean.
What do you mean when you say can only partition that which is concurrent?
In this case, there's 4-point-something years left. He could file a partition action against the other Cupert, against the beneficiaries and the trustee of the other Cupert, and say, we're going to sell 4.5 years worth of time in this house. Maybe there's a pro athlete or somebody who wants to live in that house for 4 years, maybe they would buy it. If it was 800 acres of land instead of a house, you could say for 4.5 years, we're each going to have 400 acres of land. You could have a partition action theoretically to the extent the estates are concurrent.
So you're talking about, you're considering them concurrent up to the 20-year mark.
Yes, precisely. And I do think that 1220A expands the ability to use partition to that extent, because a lot of the old common law cases would say, unless they're 100% concurrent and you really own the same thing, because historically partition was a very, very limited remedy. I mean, 500 years ago in England, it was very difficult to even hold a tenancy in common. It was only co-parsoners, sisters, who inherited because there was no brother to inherit, who were in that sort of a relationship. It was very, very narrow. It has admittedly gotten broader, and 1220, I think, does make it broader. What it doesn't do, though, is I don't think it gives you the ability to sell the whole house and try to monetarily compensate for it. And that's what I think Judge Verdeen originally anticipated in her ruling, is that somehow we'll deal with this when we get to divvying up the proceeds. But in fact, there's no practical way to do that. And if she'd stayed on the case, I think she might well, it's speculation on my part, but she might well have realized that that wasn't going to work and have rethought the situation. Unfortunately, we changed judges, and with a new judge, it's much more difficult to get typically a new judge to go back and relook at a decision that a prior judge had made.
Why can't the property be sold now and the occupancy interest of Mrs. Malhotra and Dr. Malhotra be protected through other properties, and the remainder interests of the Children's Trust be protected through those properties?
There are a couple of reasons. One is because Nira is entitled to choose where she wants to live. So again, we're back to the problem that you recognize, because you have two Cuperts. The one isn't entitled to throw the other one out and make them go live somewhere that's not where they want to live. So they're certainly prejudiced.
The trust provides that this particular property is the residence or any substitute property that might exist. So it's not as though the trust has precisely stated this is the only property that could be a residence under each individual Cupert.
No, that's absolutely true. And it has often been characterized in these proceedings that our position was that selling the house would somehow blow up the Cupert or cause the Cupert to cease to function. That's not our position. The Cupert could deal with this. The Cupert anticipates a voluntary sale on the part of Dr. Malhotra. The Cupert anticipates an involuntary sale, although it doesn't anticipate partition and it doesn't authorize partition. It does imagine that a court somewhere in some other type of proceeding, such as an eminent domain proceeding, could order Mrs. Malhotra out of the house.
Certainly doesn't specifically authorize partition, but it doesn't address it at all, does it?
It doesn't address it at all, and neither does the statute that was based on. And that's because it's a tax statute. It simply isn't likely to be the
I assume
subject.
That many of the terms of the trusts come from federal law, tax law, and so on.
But I'm going to run out of time here at some point, so I guess what I would do on this is direct you to the Evans case and say, even though the Cupert creates in these future interest beneficiaries a very limited and arguably contingent interest, I think it has to be vested for tax reasons, because if it wasn't a true vested interest, you wouldn't be able to take that tax deduction. But it can be vested subject to divestment, and the difference is minimal. Even a very remote contingent interest is protected by 1220A. And if you look at the Evans case, you see that. You see a remote beneficiary who I don't think was even born at the time.
But is that an interest in this particular piece of property, or simply in a piece of property?
It wasn't a trust, so it was this particular piece of property. But I think that the trust does give them an interest in this particular piece of property, even though it is subject to divestment by some other things happening.
That seems to me to be key here. So what's your best summary of why this is an interest? We certainly understand that real property is unique, and we place significance on that for specific performance of a contract, for example. But does that apply here?
I think it absolutely does apply, and even if you don't think it applies to the remainder beneficiaries under Dr. Malhotra's trust, because he's following the Cupert and saying, I want to sell out my interest and I'm allowed to do that, it does apply to Nira as to her occupancy interest, which is a present vested interest, which she's entitled to 10 more years of, and she's being forced out, which the Cupert absolutely does not allow you to do. Nobody other than the occupancy beneficiary is supposed to be able to force out the occupancy beneficiary.
But tell me why Nira's interest cannot be protected by the partition and the sale of her half. The proceeds of her half is then invested into another home. It may not be as nice a home. It may not be the home she most wants, but she can have a rent-free residence for the rest of her 30 years.
She will absolutely have something. That's not the issue. The issue is whether the legislature enacted this statute specifically to prevent a short-term interest holder from forcing somebody to accept something less than what they have, something different from what they have, something that is not what they want to have. As you mentioned, interests in real estate are unique, and I think that's the whole motive for the legislature to say this.
Are they always so, or is that only under a specific performance kind of situation?
This is, in a sense, very analogous to a specific performance type of situation, because the whole point is that the folks on the NERA side do not want to be forced out of the house. And if you look at Dr. Malhotra's interest, just as a practical matter, there was a lot of debate in the trial court about what is his percentage interest. And I'm not trying to say that that's the interest that should be distributed to him, because it's not. Clearly, that's not how the Cuperts work. But he had something less than a 10% economic interest. If you tried to somehow...
You were attempting to evaluate the economic value of the remaining years of his occupancy right.
Precisely,
Okay.
Precisely. And so if you were to sell the thing and try to somehow liquidate this and compensate this for the other folks for the fact that they were being forced out, you've got a very small pot of money there to work with. And that's just practical. It shouldn't work that way, but just as a practical matter, it's not there.
Is there anything in the record that explains why one of these trusts is 20 years and the other is 30?
There is nothing in the record that explains it. Typically, it is because of the actuarial life expectancies of the two different people, and you're trying to get a discount down to a level that is going to make the gift make sense.
And I understand, although I may not be correct, but I understand that to get the full tax benefit of this, you need to live out through the 20-year and the 30-year term.
That's true. And so there is a separate, once again, it's a reversion, so it's not precisely contingent, but it's an interest that may not come to pass. Both of the trustors retain the right to name somebody else as the beneficiary, which is also a valuable future interest in the nature of a reversion rather than a remainder. And again, you're depriving NERA of her right to appoint this to somebody in her will, which is a right in property and which is protected by ARS 12-1220A. I think it is extremely difficult to interpret this statute in a way that says, okay, we can make it up to this person if they're forced out. Yeah, they'll get something, but as the Beach Court talked about, what they'll get is money that is significantly less than what they would have wanted for it, and then they can go buy another house, which is significantly less than what they had to start with. That's prejudice. I will say, though, before I sit down, this whole thing can absolutely be addressed because we're in a trust, and anybody here who feels they're not being treated fairly can go into the probate court and say, under Title 14, this isn't working. I'm entitled to something different than what I've got. And the court will sit down with far more options on the table and try to figure out a fair way to deal with it. And I absolutely think the probate court has jurisdiction to do that, but not in a statutory partition action where you just say, boom, 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 sell the property, here's your interest. There has to be some ability. A probate court could adopt the time partition proposal, which if we're partitioning future interests, that makes a lot of sense. A probate court might even at the end of the day decide to order a sale, but might decide to do something a little bit different with the proceeds. Not too much different, because typically probate courts don't rewrite trusts, but they can do something. I think that's the solution here, is that there should have been a Title 14 case all along with a lot more options on the table. And I think we brought that up again and again in the proceedings, and it was rejected. I'll reserve my remaining 2 minutes, if I may.
All right, thank you, counsel. Mr. Williams?
Thank you. Lonnie Williams on behalf of the appellee. I think one of the biggest difference between the position of the parties is Mr. Arpad wants to ignore who owns the property. And you can see that the way he styled his appeal, because he wants to always convince you that Dr. Malhotra sought this petition. In fact, the order, which is the document that's subject to this appeal, finds that we're going to petition the property between two owners, and that is the two trustees, however you want to do it. And that's a crucial distinction, because in answering your questions, I went back, and you have to really start with the statute. The statute that authorizes petition, which is ARS 12-1211, talks about the owner or claimant may compel. In this case, the owner of one half of this property is a trust. The owner of the second half is a trust. That is crucial because we've had a number of hearings, one based on the pleading, one based on evidence. In both of those hearings, the trial court factually made determinations. I thought you had a question, Judge.
No,
Oh, I'm sorry.
that's all right.
You can just see the wheels turning.
And the one thing we have to do is keep in mind that we do have a combination of legal issues and factual. Mr. Arpat wants you to assume that there are no factual issues that the court determined. The trial court, in its order, made a specific finding of the ownership of the property. First, Judge Radine did in her first order because, based on the answer and complaint, amended complaint and answer, it was admitted. Legal ownership, and I use that term because that was the allegation, is in the trust of this house. Judge Bergen also made that finding in the order that we are now appealing. So we're starting from the standpoint that this is not an issue.
You mean in the trust or in the trustee, or does it matter?
It doesn't matter. The trustee actually operates on behalf of the trust, but the owner is the trust. The trustee is simply the person who can act on behalf of the trust. And that's a crucial difference, because when you now go to the language of the Cupert, and which is what they're relying on, they want to make the argument that the Cupert gives anyone, Dr. Malhotra, Mrs. Malhotra, the children, some legal interest in the property. And it is so clear that it does not. And the court in the orders, First Judge Radine, makes a finding to that extent.
You're saying they have no legal interest in the property?
They have no legal title.
They have a beneficial interest in their possessory right, don't they?
No, they have a interest in the trust estate, whatever that might be. And I think you hit on the head, because when you look at the definition of residence, it doesn't say this piece of property. It is very clear. It says this property or any other property that might become trust property. That could be under this another house. It could be money through an annuity. They have interest in the trust property. And you can go through, and counsel can't cite to you anything. That's where we get to the factual determination. They presented the only real expert in this case who made it absolutely clear during a testimony, and that's item 113 of the record, that the Cupert, the document, envisioned an involuntary sale and dealt with it. And so what would happen is very simple. And let me give you this analogy. The house burns down. It's covered by insurance. The insurance company is going to give the interest to the legal title holders, half to one, half to the other. What they do with that, they can get together and build a new house. They can go buy 2 new houses, or they can put that money in an annuity. Those were all established factually at the trial court. Interestingly, when we first had our hearing in front of Judge Radine, she asked the perfect question, and it's cited in our answering brief, and she said, doesn't the Cupert envision an involuntary sale of the property? And counsel acknowledged from that point, it does. She then went on and said, then why can't I do this? And he acknowledged that she could. So the issue is not what the Cuperts do and what they don't do. And here's another example how you can tell. The interest of my client, the trust, Dr. Malhotra's trust, is in 50% of that property. If he, heaven forbid, passed away next week, the Children's Trust would get zero. That's undisputed. It would go pursuant to his will or intestate.
It cuts off the remainder interest.
Pardon?
It cuts off the remainder interest.
It cuts off the remainder interest not only in the resident, but in the trust completely. In other words, they would get nothing from the, let's say he passes and the house is sold, they would not get any interest in that situation, whereas in a partition action, their interest in that property, money or another house, would remain. But
And should be protected.
it's protected the same way it's protected now. There's no change. The trust wouldn't change one iota. And that was, again, subject to factual testimony. In other words, the expert that the defendants brought up says, absent someone stealing money or doing something obvious that they couldn't do, that person, the Children's Trust, has no standing to do anything. And again, it's interesting that in their briefs, they want to ignore the factual determinations that the court made. It's our position that you have two issues. Is there a legal issue here? Well, undoubtedly not, because they're not saying partition is prohibited by the statute. I was prepared to argue why it wasn't, but I won't do that since they acknowledge that our statute is quite different than that in Colorado in terms of that court finding, because that statute simply said, like ours in 1211, that you can have a partition. Ours goes further in 1220. But what they want to ignore is there's a standard of abuse of discretion on the factual finding that the two Superior Court judges made. The factual findings are key to the determination of whether or not you should affirm this judgment. And they can't find any basis, any evidence to suggest that the testimony that you could have a sale, that Ms. Malholtra's interests are protected. And now I'm going to the third, assuming that you read the statute as having to protect some interest we contend doesn't exist. But if you read the statute that way,
Interest do you contend does not exist?
the interest in the Pacific property subject to petition.
Okay, you agree that Ms. Malhotra, for example, has an occupancy right or a possessory right?
No, Judge. I agree she has an occupancy right in her half of the trust property, not in that house. Because if she had an occupancy interest, the way you normally have in a life estate or in a estate for a particular term, no one can take that away. And if she had a specific interest in that house, if there was a fire, for example, you'd be required to rebuild the house so she could have that interest in that residence.
Why is this different?
It's different because if there is an involuntary term of something happens to the house, she gets her 50% under her trust. She gets nothing from Dr. Malholtra's side, and she can build a new residence.
Right.
And that's part of her trust. But she doesn't have a possessory interest in that house. Counsel will not be able to cite you any portion of the record where there was a factual finding.
What about the excuse me for interrupting, but what about the concept that we all acknowledge to one degree or another that real estate is unique?
Correct. And that is why the trust is what it is. In other words, the trust doesn't give her that right because it specifically says it's the residence or a subsequent residence required. And it has a procedure.
But it might be logical to interpret that to mean, well, if to use one of your examples, or if the house burned down, then it would be a different house. Whether it was, I suppose you could build it back identical, but normally something's different. So it's different. But what as long as that house exists, why doesn't she have a right to live in that house for her 30 years?
And so does Dr. Malhotra. So what do you do? Unless they're going to live together, that doesn't work. But let me give you another example, Judge.
Well,
let's assume one of the two.
But why aren't they stuck with that?
Because the statute doesn't say they're stuck, nor does the Cupid. Let me give you an example. Let's assume we have these two trusts. One of the two, heaven forbid, dies. under that situation, could you have a partition? Everything else is the same. If Dr. Malhotra passed away, she still has her 30 years.
Yes.
But under that situation, the interest in the property is passed by will.
Yes.
None of these arguments apply unless you assume that Ms. Malhotra's one half burdens his one half. And that's not contained in the documents.
Well,
There's no mention of Dr. Malhotra's trust in her trust. No mention whatsoever.
But the fact is inescapable, I would think, that they both knew that each other was executing and creating this, each one's Cupert.
And they each
and so they knew that one has a 20-year occupancy right and the other has a 30-year.
But Judge, but not in the house.
Why aren't they stuck with that?
Because if you go to the Cupert and you look at what she has for 30 years, it's not in this house. It's in the trust property. And that language has to be specific.
We would like to have a case right on this point, but I don't believe either side has been able to find one, nor have we.
I do not believe you'll find one, but I do believe when you look at the statute and it says the owners, and you look at the record, it will find that the record, in this case, made a finding that the legal owners were the two trusts. The trial court, based on the evidence, made a finding that under the partition statute, the children's trust had no interest and they could not be prejudiced because they had no rights. That doesn't come from me. That comes from their own expert, that she made that perfectly clear.
No right, you're saying, in this particular property.
No right in this property, no right to talk about a sale, no right to prevent a sale. Their rights would remain as it is under the Cupert because their rights are not in this residence. Their rights are in the trust property, and their rights are separate. See, one of the problems with the appellant's argument, if they want to treat these two Cuperts as one, whatever rights the Children's Trust has in Dr. Malhotra's trust is there. Whatever rights they have in hers is there. They're not the same. They are different. And so
They start at different times.
they end at different times, yes. But it doesn't change. It doesn't change what their rights, and I think you have a factual finding based on the testimony that if a sale were to occur, the rights of the Children's Trust, and again going to the third example, would not be prejudiced. That was a factual finding that if you read the statute under your third scenario, the trial court would have to make, and it was made early on.
It would not be prejudiced because the proceeds would be traceable into additional homes or annuities, and with a remainder left over, one would hope, at 20 years and 30 years.
Exactly. I would put it a little different, and that is the trust property, whatever it is, remains the same. Whether it is 50% of a resident, whether it is an annuity under the GAT, or whether it's another property, and that's the way the annuity is set up, and that's what the testimony was. So we don't have a pure legal issue that you can decide, and they aren't attacking any of the factual findings that the court made in terms of ownership, legal ownership. Let me point out one thing, too, and I think it's important that the cases that have been cited to you, they all deal with ownership of a specific piece of property that wasn't in dispute. Even in the one case they cite where there was an oral agreement that the mother had a life estate in the addition she built, the interest was in a specific piece of property. In this case, there was no argument, nor has there been any factual finding that Mrs. Malhotra has any legal interest in this property. She can't sell her interest. Dr. Malhotra can't sell his interest. They can't mortgage their interest. They have no indicia of ownership with respect to this property. Now, the trustee can. And that's why this case, this petition, count one of the amended complaint was between one 50% owner and another one. And the order was specifically says that she's ordering petition between two fee owners. When you go to the Corporation Commission, the recorder, and this is in the order, you will find the transition of the property. It was community property. They both agreed to put it into trust. Since that time, there has been no document changing the legal title to this property.
By the way, I was looking for a deed from one or both to deed the property into the Cuperts. I didn't find a deed.
You do not have a deed, but you have a unquestioned finding that the court made in the order that the property, that 50% of the property was transferred into the trust. It wasn't disputed, and therefore there was no document necessary to prove that, but that was part of the original judgment on the pleadings, and it also went into the final order because the trustee of Mrs. Malhotra's trust acknowledged that he was the fee owner, the trust, of 50%. So again, all of those factual findings are there. I would suggest that, again, when you look at these other cases that you have, they're all dealing with interest in specific pieces of property. None of them have a situation where something could happen that took away any future interest in something. And the fact that these two people could have sold the property, bought another one, put the money in annuity, done it individually, all of those things distinguishes this case because there's no interest in that property. And if you look at the Cupert, it makes clear that their future interest is in the trust estate in 13.02, which is the one everyone acknowledges, says the Children's Trust has no interest. And with respect to Ms. Malhotra's interest, in terms of that 10 years, it is clear that her interests relate to her 50%, and she has that, and she will have it if the property is sold and petitioned. She will have the same rights she would have if the property burned down or if the property were condemned, nothing different. And I don't think that's disputed. I have another minute, but unless you want me to waste your time, I don't have anything else unless you have any more questions.
I do not. Thank you.
Thank you very much.
Counsel?
Yes, Your Honor. I have limited time and several things to get through. I'll try to do it as quickly as I can. First of all, the supposed factual findings are about interpretation of the effect of a trust as a matter of law and interpretation of a statute. Second, none of the testimony of our expert was inconsistent with what you would find if you read those documents carefully and understood them, so it doesn't really make a difference. Third, dispositive provisions of the Cupert, 5.031, use and occupancy of residence. During the term of this Cupert, the trustor shall have the exclusive right to the use, occupancy, and enjoyment of the residence as a personal residence without the payment of rent. It doesn't say unless somebody takes it away from her and perhaps she'll have an interest in something else. The whole concept of a Cupert, and we've cited you that law, is that the owner has to retain the control and the occupancy of the residence during the term of the Cupert. That's important.
How's the residence defined under the Cupert?
I will have to look it up for you, Your Honor.
Is that section 2.03?
Yes. The term residence shall mean the real estate described in Schedule A and any substitute personal residence acquired by the trustee in accordance with the provisions of this agreement, but the accordance with the provisions of the agreement is that the trustor has to control that. If the trustee under a Cupert can't say, you know what, Mrs. Smith, I think you should go live over there, The trustor has to remain in control and be able to do it, or it doesn't qualify as a cupert. It's a critical distinction.
No, I'm not sure I just followed what you, I'm not sure I followed what you just said. Would you do it again, please?
A cupert requires, by regulation and to some extent by statute, although the statutes are pretty impenetrable, requires the trustor to retain the right to live in the house, to live in the residence, in order for it to be a cupert. Now, they can sell it if they want to and go live somewhere else, or they can convert it to a grat. Those are specific powers that they retain to do. But they don't give the trustee or anybody else the right to make that decision for them. If the kids or anybody else could come in and say, I don't think you should live there anymore, you should go somewhere else, it isn't a cupert at that point.
Yeah, but what about when two people each have a cupert, they're married, and they get divorced, and now it's time to separate these?
I absolutely think the probate court under Title 14 can figure out what to do and can have a lot more options on the table to do that fairly than a court of law has under the partition statute that says, sorry, sold, you're done. That's essentially it. I'll let it go because I'm out of time.
Mr. Presiding Judge, I have a question for one or both of these gentlemen. May I ask?
Yes.
You know, with certain presiding judges, you have to be very polite when you ask. We understand, of course, that we have pending a motion to stay. Is there anything that either of you wishes to report to us on the urgency regarding that?
My understanding is that the way the stay was set up, more or less by stipulation, is that nothing's going to happen until you issue a decision on the stay. And judging by the way things have gone forward, my sense is you're not going to do that until you've decided at least the substance of the merits. So from our point of view, there's no urgency, and I'm not aware of any offers that are any different from the ones that were submitted previously. I'll let Mr. Williams speak to that if he has.
I think counsel's interpretation of the order is correct. We do believe there's urgency in the sense that what the appellants have gotten is an automatic stay by the filing and their action without the posting of a bond. But we do agree that the order is in the order we obtained does not go into effect until you rule on the motion to stay.
Well, if I may, Mr. Presiding Judge, I would just say if we don't get a ruling out to you right away and something changes that changes the urgency from either of your points of view, feel free to let us know.
Thank you.
Thank you, Your Honor.
All right, counsel, we'll take this matter under advisement, and we will issue a written decision in due course. Court's in recess.